All right, the next matter we're going to address is People versus Natalie Welch. Miss Welch was charged with possession of meth.
And here we go. Buckle up. This case centers on a 20-year-old tangled up in a cocktail of charges: meth, cocaine, fentanyl, and more. Not exactly the kind of starter pack you want at that age. It's a reminder that addiction doesn't wait until you're older. It drags people in early. She's barely out of her teens and already in the deep end. The big question is, does the court see potential for change, or just another tragic statistic in the making? Let's see how this unfolds.
Possession of cocaine and possession of other controlled substances. She was arrested on November 2nd, 2024. Then the warrant got issued and she got arrested on April 14th of 25. It was set for a felony charge, was reduced to a misdemeanor, pled to use of a controlled substance on April 29th.
Pause. Did you catch that? Felony charges reduced to a misdemeanor. That's not just a legal technicality, it's a massive break. In plain terms, instead of years behind bars, she's down to a lighter charge with a lighter sentence. But make no mistake, this comes with strings attached. Show up. Stay clean. Take the court seriously. Judges don't hand out leniency for free. It's like being put on probation by life itself. Slip once, and that rope gets pulled back fast.
She was set for a sentence today with a pre-SI interview on May 16th. That didn't go very well, and she's not here this morning. I frankly didn't know what to do with her. We're talking fentanyl, heroin, cocaine, methamphetamine, not trace amounts either. She's 20 years old, on the road to nowhere, and so I referred it to Mr. Frazine for some help.
Right. That line right there, road to nowhere, hits like a punch to the chest. The judge isn't sugarcoating anything here. At just 20 years old, her choices are already painting a path toward tragedy. Think about it. When most people are starting college or careers, she's facing prison walls. The warning is crystal clear: keep walking this road, and there's only one destination. Unless something changes fast, her future is already written in bolding.
I think he was just as frustrated as I was, and now she isn't here. Have you had any contact from her?
I told Dan she's called the office, because Dan told her to call the office, and every time she called, I was either in court or I had just walked out the door. Like, she called like late in the day. And so then I haven't had no contact. She has a working phone number. We sent the notice by email and mail. So she got it 2 ways as to the date of sentencing.
Plus, I gave it to her in the courtroom.
Okay, so yeah.
And I reminded her, and she said she'd be here, but
I don't know. This
Was she staying with her parents?
says she
Yeah,
was staying with her
Colon.
parents in Colon.
Yeah,
Do we have like a number where you can call to see if she?
I have a phone number for her, Your Honor. Do you want me to write it down for you?
I've got
Oh,
it.
there
Here
she
she
is.
is. All right. And that arrives late.
She finally shows up. But here's the catch. She strolls in late to her own sentencing. Question for you. How do you think that sits with the judge? Spoiler, not well at all. Court isn't a coffee date you casually wander into. Judges read lateness as pure disrespect, like saying their time doesn't matter. And in sentencing, optics matter. Walk in late, and you've already lost before you even open your mouth.
As I stated, I think before she got here, charged with possession of methamphetamine, possession of cocaine, and possession of heroin or fentanyl. Heroin and fentanyl. 4 counts, was reduced to 1 count of use of a controlled substance. The matter was set for sentencing this morning. Daniel Frazine has been tasked with preparing the pre-sentence report There was some trouble getting her in for the pre-sentence report. We did finally get it done. Mr. Friesine shares many of the same frustration I do in figuring out what to do here. Ms. Hines, what would you like me to know?
Your Honor, before we go forward, maybe, I would ask that the court consider canceling her bond and having a drug test before we go forward based on her admissions of use and her admissions of continued use while on bond to Mr. Friesine. I have concerns that she might not be coherent and with us enough to do a sentencing today. I'm certainly willing to have her come back tomorrow or when the court is available, but this is
Fair enough.
a pretty
Well,
significant reduction that was given.
When
for-
people come in with alcohol, I had a young man here recently, his blood alcohol level was 0.14, and we were about to do the sentence. We have a standard of how high is too high. And he was almost 1.5 times the legal limit. We can't proceed with a sentencing when the defendant's intoxicated.
You can't proceed with a sentencing when the defendant's intoxicated. And yes, that happens more often than you'd think. Great point here. The law requires the defendant to be clear-headed, aware, and fully able to understand what's happening. If you're drunk, high, or otherwise impaired, the court has to press pause. Think of it like signing a contract. You can't agree to terms if your brain is fogged. It's not just procedure, it's about fairness and accountability.
She needs some help, 20 years old. It's concerning that, like you said, Your Honor, she's used pretty strong illegal substances that really will ruin her life.
Yes,
She doesn't get out control of it.
the struggle is between just letting her go over the waterfall or trying to intervene. She is 20. And these weren't trace amounts.
One powerful image, the waterfall. The judge is standing on the edge, weighing two paths. Let her go over and face the natural consequences of her addiction, or throw her a lifeline and try to pull her back. That's the tension at the heart of this case. Do you let someone hit rock bottom, or step in before they do irreversible damage? Judges walk that line every day, balancing mercy with reality. And this moment captures that struggle perfectly.
6, 7 of meth, some 1 point some of or 3.5 of some other stuff, then the cocaine, the fentanyl. I forgot they were in there. Addicts don't forget they got user amounts of controlled substance in their possession. She doesn't know whether her boyfriend uses drugs or not. So I don't think she was really upfront about everything. So I'll cancel the bond. I can't get in my scheduling profile right now. Laura, do you know what your schedule looks like this week?
Tomorrow I'm in Judge Patterson's courtroom at 9:30, and then I have a sentencing from 11:30 to 5 in Sturgis.
11:30, a sentencing.
A divorce mediation.
Oh, okay.
Sorry.
It just feels like
It feels like it. Especially this one. So I will be in mediation.
How are you for Wednesday?
I have an adjudicatory trial. Yeah, that's set for all day.
How are you for
But,
Thursday?
I have some people in my office, but I can work around that, Your Honor. We can move people if I need to, so.
Laura, what do I have for Thursday? It wouldn't let me log in first thing this morning in my ongoing litany of technical problems. I still can't get the Kramer box to work for the Javs recording and wouldn't let me log into the AS400. So
I'm assuming you have, does he have PCs tomorrow?
I have PCs tomorrow.
I mean, I could be over here in the morning. Like I saw next.
All right, why don't we set it for 10 o'clock tomorrow?
That's fine.
Does that work for you, Ms. Davis?
I'm doing PCC, so I'll be here. I would like to have a screen still up there.
Well,
just to verify.
Then there's some, we have to transport her to Three Rivers and somebody has to pay for it. We don't have a funding source to pay for her test.
I mean, I think if it's just a matter of getting a urine sample and she's not able to right now, I can, maybe she could within the next hour.
Okay, so we even get a urine sample.
Yeah.
All right,
I'm around all afternoon too. I mean, I have,
we'll
some
set up
hearings
for
with
tomorrow
Judge
at
Middleton, but other than that, I'm available this afternoon.
I guess I am interested, Ms. Davis, in knowing whether there's any opioids in there as well. So we're gonna wait until we get a test. All right, tomorrow at 10. Let's see what I got. No, I tried to call Chris because it won't let me in the AS400, but Thursday would have worked also. All right, we'll take it up tomorrow at 10 a.m. here in this courtroom. We're gonna have her wait till she can give us sample, and we'll see really what it is we're dealing with.
Can they give her some water or something to drink?
Yeah. I'm concerned if there are opioids in there as well. We hadn't seen cocaine in a while, and it started to make a resurgence. All right, Ms. Welch, you go back at the lockup. At some point, she's gonna need to get lunch, so I'm not sure. We'll work with Autumn and see what we can do. Hold on to her for now, then we'll see what Autumn wants to do.
Should I leave her phone in here? Because we're not.
Time cancellation.
Yes.
All right. We'll see you tomorrow.
Is Miss Welch here? Okay. You heard the results.
I
She
only.
was positive for everything. Lori,
Lori.
your client was positive for methamphetamine, fentanyl, cocaine, and
The toxicology report? It's basically a bingo card, positive for almost everything. Marijuana, meth, cocaine, fentanyl, her system was running like a full chemistry lab. It's not just one bad choice. It's a pattern spiraling out of control. When every test comes back lit up like a Christmas tree, it screams dependency. This isn't recreational use. It's survival through substances. And that's the scariest part because it shows how fast control slips away.
perhaps something else. Marijuana.
Does Autumn have a test result or something?
No, one of the issues is just an instant test, but her report back to the court was the defendant was positive for
So
methamphetamine,
fentanyl.
marijuana, fentanyl.
Does it show levels or just?
No, it doesn't.
Just what you-
It's an instant test, so the levels would have been high because it's not a very discriminatory test.
Well, I think from watching her come in. Already has concerns that she is detoxing. I did meet with her. They believe she's in her beginning stages, so she is a little fidgety.
Would you, well, let's see.
Anxious, so.
She's positive for opioids and methamphetamine. If we wish to continue it, her family's here. We're going to return to a sentence that we began yesterday. People versus Natalie Nicole Welch. Good morning, Ms. Welch. You're here with your lawyer, Lori Hines. You pled guilty to a charge of use of a controlled substance. I referred the matter for a pre-sentence investigation, and Daniel Frazine prepared a sentence report. Mr. Frazine's not available this morning because he has a family emergency. He called me first thing. But he stands by his report. Ms. Davis was here yesterday and your lawyer, Ms. Hines. We asked to do a drug test and you had represented that you weren't able to provide a specimen, you would be positive for methamphetamine and marijuana. Ms. Davis's position was, I would really like a test. So we waited, actually, you waited through the lunch hour, and Autumn Kiefer from our probation department did a test, an instant test, and that you were positive for everything: methamphetamine, fentanyl, heroin, cocaine, and marijuana. 20 years old. And frankly, it scares me. I understand that you've been in custody overnight. You may be withdrawing from some or all of these substances. How are you doing this morning?
I'm doing fine.
All right, so you want to proceed with the sentence?
Yeah.
All right. Ms. Hines, in light of everything that's transpired since yesterday, anything else you'd like to say?
No, I did meet with Natalie. I told her what her test results were. I asked her questions because I know the jail staff was concerned that she was starting to detox. So we had a discussion about health insurance and possible rehab, and she definitely needs some help. Jail time would only give her forced sobriety and not really work on issues, the underlying issues of why she continues to use. And it's my understanding from talking to another attorney that had her previously, this has been going on for about 5 years.
Yeah, you're 20. Ms. Davis, you were astute in asking for a final test rather than just her representations. Anything else you wish to say here?
Your Honor, after the hearing yesterday and hearing what substances she was positive for, obviously the concern was that she's on bond for what were felonies, reduced to a misdemeanor. At age 20, she has got an addiction that is so significant that she can come into the courthouse with those substances in her system and still appear relatively, quote unquote, normal, speaking, walking, not passed out. I did inquire from an individual that knows her from school to see what's the background here. And I don't think that Natalie realizes how many people care about her and are pulling for her and want her to do well, and recognize that she had a very difficult upbringing, very difficult family situation, and perhaps that's not the healthiest place for her to be in order to be sober. With that in mind, I would ask the court to consider doing a period of 90 days jail up front, that if she is able to get into an inpatient rehab facility.
It's called a shock sentence. The idea? Give someone a taste of jail up front, enough to scare them straight. It's not about cruelty, it's about reality. A few days or weeks behind bars can jolt a young defendant into realizing what's truly at stake. Often, judges pair this with rehab, so the defendant gets both structure and a fighting chance at recovery. It's tough love with strategy behind it, but does it actually work long-term? That's always the gamble.
That she'd be allowed to do that, but it would be as a term of this so that she wouldn't be able to just voluntarily sign out. And that upon completion of the 90 days or completion of that inpatient, that she would then be on probation. I would request that it be 2 years based on the length of time that she has had these significant issues, and the fact that while on bond, she has admittedly continued to use and hasn't been able to kind of seek out the resources that can help her. So with that, I would ask the court to take that into consideration. Thank you.
Yeah, it's an absurd situation we're in. The law, more of the Criminal Justice Reform Act presumes everybody's going to be free on bond. There's a presumption that there's a PR bond, certainly a presumption of bond. We used to do drug testing at the Day Reporting Center. We had funding for it from the Community Corrections Grant. Now we just tell people that are addicted, don't use any drugs. And the point of fact is almost everybody would test positive between the date of the pre-exam and the prelim because they're addicted to very powerfully addictive substances. You scare us, Ms. Welch, because there's so many things involved here and you're so young. People don't die from methamphetamine overdoses. They decay over time, and we've certainly seen it. People die from fentanyl overdoses. You got other stuff in there, including cocaine, and some other, and marijuana, and perhaps other prescription stuff. It's frightening. I talked to Mr. Frazine on the phone this morning, and I think we're all on the same page. You need some sober time. We're going to try to see if we can find an inpatient treatment program for you as a condition of your probation. I can amend your jail sentence to let you into an inpatient program. And that's what Ms. Davis suggests. That's what Mr. Frazine suggests. But you need some forced clean time. So I agree with Ms. Davis. You need 24 months of...
And that's the bottom line. Addiction doesn't politely pause because you're standing in front of a judge. It follows you right into the courtroom. The judge knows this. Unless she's physically removed from access to drugs, recovery is just talk. That's why so many courts lean on tough love, locking someone down to keep them alive. But here's the debate. Should courts push more on treatment first, or is confinement the only real shot? What would you choose if it were up to you?
Is zero. There's a $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee, and a $960 probation oversight fee. You don't have very much money, so this isn't so much about money. $12.35. No drugs and no alcohol. Test as directed. Also need other treatment. May be released to an inpatient treatment facility if we can find one. So it could be as soon as one as would be available, I suppose, but it'll be the kind of probation that Ms. Davis reflects, that you can't just walk away from it. If we sent you to a treatment program, it'll be a condition of the probation that you participate in it. And if you walk away, it will be a violation of your probation. You'll be back in jail. But right now, you're going to have a rough couple of days. All right, I don't know, she'll be in the jail for some time, potentially as long as 90 days minus good time, which would be 75 days. But I'm envisioning that between then, before then, maybe sooner rather than later, we're going to get you into an inpatient program. I don't know where you're getting these drugs. They weren't trace amounts. You had usable quantities of meth, cocaine, fentanyl, and maybe heroin. Spooky. All right, I don't wish you any ill. I really don't. We've seen you before. I've been here for a long time. And I see what the toll of drugs do to a 20-year-old girl over a 20-year period. And it isn't pretty. You deserve better. So you're going to go to jail. You're going to be there for a while until they can find a place for you to go. Do you have any questions? I understand Autumn kind of was hard on you yesterday back in the lockup. I think she gave you some good advice. You deserve better than where you're headed. So let's see where we can go. So you're free to go.